So what is the Jordan decision? Barrett Jordan was charged with drug offenses and then trapped in a legal limbo, unable to get a trial date for 4 years. The Supreme Court said that was a violation of his charter rights, and it put hard limits on how long prosecutors have to try criminal cases. 18 months in provincial courts, 30 in superior courts. CBC News has counted more than 400 cases since then, including some for murder. They've been stayed because they missed that deadline, most of them eventually thrown out. And as Carolyn Dunn explains, the impact of the decision has spread beyond the criminal law.
In a wooded lot a half-hour north of Edmonton, Sandra Paraderi is living a life more rustic than she ever could have imagined. Firewood for heat from a wood stove.
And no running water, no.
No running water. No electricity.
Paraderi's common-law husband died 4 years ago, but there's a legal battle over the estate. She can't get her rightful share until it's settled. She's broke, living mainly on a survivor's pension and the goodwill of others. Her lawyer says if that case goes to trial, it probably won't be scheduled before 2021.
I get it. I got to start over, but I didn't think I was going to have to start over from under the barrel, not even the bottom. It's twisted.
Hers is one of an untold number of civil cases facing lengthy delays, systemic delays that in some jurisdictions seem to grow only longer with each passing month.
Part of the problem comes courtesy of the Supreme Court of Canada in what's known as the Jordan decision of July 2016. It ruled criminal trials must be completed within 18 months for relatively minor cases or 30 months for more serious offenses. The system is straining to meet those deadlines, and in some provinces, they're using civil court resources to do it. Recently retired Chief Justice of Alberta, Neil Whitman, says the civil court system is suffering as a result.
You cannot keep up the pace that this court is presently being subjected to for long periods of time and get the quality of justice that I think the public deserves.
In Calgary, for example, the wait for a civil trial in 2016 averaged 92 weeks. This year, that wait has doubled. Alberta is perhaps least prepared to deal with all of this because the federal government has failed to fill a dozen judicial vacancies.
Maybe one of those positions has been filled so far, maybe one.
Mark Feehan is president of the Alberta Civil Trial Lawyers Association and Sandra Paraderi's lawyer.
You don't want alleged murderers walking the streets. And we all understand that. But the people that have non or less serious, like family law or estate arguments or personal injury, they all just kind of got put on the back burner.
The people like me, I don't even think we're on the back burner. I think we've been put on the side to cool.
Where she counts the days, waiting for justice. Carolyn Dunn, CBC News, near Edmonton.
So courts stretched thin, those accused of crimes waiting years for their day in court. A Supreme Court ruling that forces action and creates commotion. The Jordan decision sounds unprecedented, but it is not.
In what's become known as the Ascoff decision, the Supreme Court of Canada ruled that an accused should be able to go to trial within a reasonable time.
Before the Jordan decision, there was the 1990 Ascoff decision. Back then, the Supreme Court suggested anything more than 8 months was an unreasonable delay. In Ontario, in particular, the impact was dramatic. The province scrambled to appoint more judges, approve more money for courts, but the accused in 25,000 criminal cases walked away.
How do you feel right now?
I got a permanent smile on my face. I feel very good. It's all over.
In 1992, the Supreme Court softened its position and the judicial chaos subsided.
It would have been helpful if the original Ascoff decision had clearly stated that the principles set out there were principles and were not rigid timelines.
But the problems that sparked the Ascoff decision got worse across the country. And decades later, rigid timelines for criminal trials are back, and so are the consequences. Well, Ian Carter knows a lot about these issues, a defense lawyer in Ottawa and also vice chair of the Canadian Bar Association's Criminal Justice Section. And Ian, I know the CBA has been talking to the federal government about how to reduce the delays in court. Give me one example of something you hope to see tomorrow.
Well, one of the things that we've recommended is to deal differently with more minor offenses and what we call administration of justice offenses. So I'll give you an example. An individual is arrested and charged, released on bail. Part of those bail conditions is not to drink alcohol because the individual has a dependency with alcohol problem. He then goes out and he's caught consuming alcohol, and he's arrested again and brought back for more charges, more court time, more use of prosecutors and defense lawyers. And that clogs up the system. By dealing with those kinds of matters outside of our regular criminal justice system in an administrative way is going to save a huge amount of time and resources.
It sounds relatively simple, but sometimes in the criminal justice system, simple things take a lot of time. Do you think that's a change that will be made?
I think that that's something that they've been talking about, and particularly dealing with the issue of administration of justice offenses, and I would expect to see something in the legislation tomorrow on that.
And the CBA has put together, and I think you were involved in this, a kind of a top 10 list. It includes things like what you just mentioned, also things that will cost a lot of money, like more judges. But tell me so far what impact the Jordan decision has had that you see when you're in Ontario courts.
Well, I think to be quite frank, it's sent shockwaves through the justice system. All participants that I see, from judges to prosecutors to defense lawyers, it's been a wake-up call. And you see, in terms of new procedures locally, in terms of the way cases are treated, there's a huge attention on delay issues that, quite frankly, didn't exist before. Part of the reason in Jordan was to shake the participants out of their complacency, and I think it's had that effect already.
And I've heard similar stories from judges right across the country. Ian Carter, thank you very much.
Thank you.